First, I want to thank you and the ranking member for holding this hearing. Notwithstanding your comments. As the arbiters of justice in our country, the impartiality of our judiciary should be beyond reproach. Justices in the Supreme Court may be the most powerful people in our land because their decisions are not appealable and they've got lifetime appointments. They have control and actions over our bodies, particularly women's bodies, and our actions in so many ways. And yet they're not have any particular ethical standards or restraints, not bound by an ethical code of conduct. And that just seems wrong. The whole idea of giving judges at all levels lifetime appointments is to get them free of any earthly desires that they may fall prey to, and that they could be fair and impartial. But at the same time, because they've got lifetime appointments, I've been hearing we can't really sanction them for violating any rules, which seems like a catch-22 of some nature. Hamilton correctly said the judicial branch has neither the power of the sword nor the purse. Professor Jefferson, what does the judiciary have to do to get parties to abide by any rules that they might set forth? Is there anything we can do to get the Supreme Court to take action?
So Congress can require the Supreme Court to adopt a code of ethics. I think a really important point to make here, though, is so there's been a lot of conversation that we can't sanction the federal judges. But what I don't think any of us want to be sanctioning federal judges. What we want is compliance with ethics rules. And so the Supreme Court and the lower courts, the key to compliance is public accountability. And we can predict how the judges will respond because we saw how they responded when each one was called, at least a lot of them responded when they were called up by the Wall Street Journal and it was pointed out that they weren't complying with this law. Many of them followed up with litigants to let them know what happened. Many of them took steps to correct the situation. And so imposing that similar kind of accountability by not just requiring an ethics code, but then showing how it's being complied with. So for example, not just requiring disclosure of one's finances, but maybe requiring disclosure of recusal decisions. If a judge is required to actually explain the basis for recusal, there are several important things that happen. One, there's accountability for that individual judge because he or she has to justify the decision to recuse or not recuse. But critically important, it becomes an education tool. Another judge thinks, oh, in a future case, I saw that a different judge recused. I should probably recusing too. And also for litigants, same thing.
And that's wonderful, but what if they don't do it? What if they don't comply? What if they don't care? Well, your only penalty is shame.
Yeah, and shame could be powerful. I mean, one of the points that I make in my written testimony, I said in my open statement—
Shame doesn't exist anymore.
Well, I think that may very well be true, but it would at least get us closer to more judges adhering to the rules if we knew there was a public list of judges who weren't complying. We at least now have more judges.
What are you going to do? They don't lose their job.
Well, true. I mean,
they don't lose their brokerage account.
Taken to the extreme, it would have to be impeachment, right? Yeah.
Right. And we've seen how good that is.
I understand.
Yeah. Do you have any, Mr. Hedler, Gaudet, do you have any ideas about what we could do to try to make these, can we take away, give them a financial penalty? Can Congress have a law that says if they don't do it, that they lose X amount of money for each failure to comply?
Thank you. So I think it's a bit beyond my expertise to say whether that would be an appropriate avenue to take, although I would point out this is something that I also feel passionately about, that Congress does emphatically and unequivocally control the power of the purse. So there are a number of things, with the exception of reducing the salary of a federal judge or a Supreme Court justice, that you all can do if you were willing to more aggressively and assertively use the power of the purse around funding of facilities and that kind of thing.
Professor Green, you're out there somewhere, I guess. Maybe not.
Yes, here.
Oh, I see you. There you go. And the power of the purse. Can we really do that? Can Congress reduce the salary of a judge during their term of office? Isn't there some limitation on our reducing the salaries of judicial officials?
Yes, so Article 3 says that the compensation of Article 3 judges can't be reduced during their time in office. So that would be a limitation,
Yeah.
although other uses of the power of the purse may not necessarily be limited in the same way. So
Well, take away their
altering the
interns,
staff
take
of
away
the
their
court,
staff.
that sort of thing. Conceivably, it's never been tested, but and there would be an argument about it that it would be resisted. But there's no clear constitutional prohibition on that, no.
All right, I'm over my time, and I've got other questions I'll just put in writing, but I do want to make this comment. The Wall Street Journal story cited many judges. I don't think I knew hardly any of them except for the Sixth Circuit Judge Julia Gibbons. I do not know, she's of a different political party. I don't know of a judge or a person that I've known who's more respected for her rectitude, for her probity, and the fact that she had, or her husband had some minimal amount of stock in some company that she may or may not have known about is kind of absurd to think that would have affected her opinion whatsoever. So I say, you know, I understand disclosure and transparency, but I put Judge Gibbons over the Wall Street Journal any day. I yield back.